Number 113, People versus Dennis Sincerbeaux.
Good afternoon. May it please the Court, Mary Davison on behalf of the appellant, Mr. Sincerbeaux.
Ms. Davison, would you like to reserve any rebuttal
Thank you
time?
for reminding me, Judge DeFiore. 2 minutes, please.
2 minutes.
My client, like every other offender who is labeled under SORA, has the liberty-protected interest of being labeled accurately, and I respectfully submit in this case he was not labeled accurately, and thus brings his case before the Court for its consideration. First, with respect to this argument, I would submit that the SORA court abused its discretion as a matter of law in its determination to deny the downward departure under risk factor 9. My client had previously been convicted of an endangering the welfare of a child misdemeanor offense, or an EWOC, some 20 years prior to his...
Did you request a downward departure?
Yes.
You didn't call it that, right?
I believe that the trial attorney did call it that, Judge Stein.
And what were the mitigating circumstances that were argued in favor of a downward departure? Any circumstances argued in favor of a downward departure?
If you look at the three-prong test that it comes from Galoti, is it, I pronounce it correctly, Galoti? The first prong says that it has to be something that's not otherwise taken into account by the guidelines. And I would submit that because in the guidelines themselves they allow for this downward departure just by virtue of the fact that that there is no sexual component to the underlying EWOC conviction, that prong is bypassed and goes next to the defendant's burden to show by a preponderance that, in fact, that's true, that there was no sexual.
So how does our recent Howard case impact the analysis about whether points should be assessed or a downward departure should be granted?
Well, Howard, of course, was different because it involved an automatic override, and it's not the case here at all. I would submit, I did in my...
There was no sexual component to that crime either.
Right, but you started at a different point. You started with the automatic override. Here...
Just discretionary. It doesn't have to be applied.
But what's not discretionary is the guideline in a case like this telling the SORA court that it may consider a downward departure. In other words...
But what's the proof that they didn't consider it and just not do it?
Well, the decision, I think, first of all.
What specifically does it say? I mean, yes, you can look at that as a basis for downward departure.
The court never specifically...
You can... It's 30, right? You argue it should be 5 because there's no sexual component to it?
Well, it's an interesting question because the guideline says the fact that there's no sexual component may warrant a downward departure. Right. It doesn't say you get a 5.
Right.
And we asked for a 5. We asked the SORA court to convert
so that would be a downward departure,
30 to
right?
a 5. So I think it's a downward departure to a different level.
Right.
And I don't, in this case, they asked for a one-step downward departure because the 25 points would have pushed him down to a level 2. Sure. But I don't see in the guidelines where that's actually ever articulated. It just says, as a matter of discretion.
Score, but I thought they're conceding these 25 points, so why do we have to reach that issue? They concede
They're
it.
conceding it as a matter of law. I recognize it in Howard. It would be a matter of an abuse of discretion as a matter of law, and they didn't address that. If the court considers that concession with respect to abuse of discretion, I'm fine with that. I won't address it any further. The second component, though, is, and in a sense, it addresses the question of whether the court had sufficient grounds, is with respect to risk factors 1 and 5. Did the court have, did the people prove by clear and convincing evidence that this conduct began when the complainant was 13 and involved the use of force or the use of violence? I would submit that the case law, Mingo specifically, allows for the admission of reliable hearsay. But in this case, there was no reliable hearsay. In other words, what was put before the SORA court was not similar to the other cases that this court has reviewed or that the departments have reviewed.
What are you suggesting was put before the SORA court that was not reliable?
Well, for example, my client was charged originally with incest that occurred between August and September of 2007, I believe. Incest has no component of age, and in 2007, the complainant would have been 25 or 26 years old.
Is the SORA court limited to those specific acts charged within that August to September period?
No, but I would submit that this is different than cases like Mingo, where there's something that's reliable, something beyond simply...
What about the victim's sworn statement?
I submit, and we submitted to the SORA court, this was not a sworn statement. The victim says specifically, I state the following. She never says, I swear to it. It's not sworn to.
Why does it have to be sworn? Hearsay is permissible, as you say. Why wouldn't this be admissible, reliable hearsay coming from the victim, with some corroboration about DNA and...
Well, sure. Hearsay
which
is...
would go to timing beyond...
Mingo talks about sworn statements of the victim, and maybe it's splitting hairs.
About
but-
statements that have the form notice across the bottom. Isn't that what this statement had?
The statement
false
says-
statements are punishable?
The statement says, I recognize I can be prosecuted if I made a false statement. It never says, I swear this is true. And again, it may be splitting hairs, but it never says that. Moreover, my client puts...
I'm sorry, what is there to suggest that the complainant is not telling the truth?
my client's statements controverting this, and I submit that by making those statements in the context of the pre-sentence report...
That cannot work under Mingo, because obviously those kinds of respondents in the same position as your client would have also controverted.
I respectfully disagree, because remember, Mingo deals with corroborating factors, sworn statements. For example, the police officer...
But it covers files, as Judge Steins already pointed out, may include double hearsay. The hearsay heard by somebody that then gets in a document, that's another level of hearsay.
But it doesn't cover prior bad acts. So if you plead guilty to a rape that satisfies an original complaint of sexual abuse or endangering the welfare, for example, that's what Mingo covers. These are incidents that happened in 1998, some of them. These are incidents that are not corroborated by contemporaneously...
But do you dispute that other than your client saying that's not what happened, that this is what one would otherwise say is reliable, the person themselves saying this is what occurred?
There is no DNA. There, in fact, are statements by the complainant saying, I'm not sure who the father of my children are. Then certainly there was a DNA test that established that another party was the father of at least one of the children. But I think in this case it has to be considered that if, in fact, my client's version of these incidents is correct, and that would certainly be up to the SORA court to determine, then in fact the complainant in this matter is a co-defendant in the incest. And as difficult and as unpleasant
Wait,
as...
say that again, the complainant?
The complainant is a co-defendant in the incest because she would have been a consenting adult who engaged in this relationship with a person of consanguinity. So although it's a difficult concept to absorb, you have to consider that in a sense she's a co-defendant giving statements against a co-defendant, and this court...
So are we disregarding her statements completely about the force and the time the whole series of events began from when she was first moved into the home with her father?
I would submit that it was up to the SORA court to begin the clock at age 19, which is the age at which my client admitted
And you're saying that's because of the statement that she gave doesn't meet the test of being a sworn statement?
Nor is there any corroboration, nor, as in other cases, are there contemporaneous sworn police reports, nor are there felony complaints, nor is there an indictment, grand
Are you
jury.
familiar with our case called People v. Sullivan, in which the court held that the form notice across the bottom of a person's statement is a functional equivalent? And I think the exact language is, we believe the statutorily authorized form notice served as a procedural and functional equivalent of a more traditional type of oath or affirmation. And I'm wondering how that squares with your argument.
Again, I think it was incumbent on the SORA court, when these issues of fact came before it, to put the burden on the people to prove by clear and convincing evidence that that version of events was the accurate and reliable version of events, and I think that they failed in that regard.
Thank you, counsel.
Thank you.
Counsel?
My name is Bruce Rosecrans. I'm representing people state of New York.
What exactly are you conceding? Are you conceding that there can never be points awarded under risk factor 9, if the endangering conviction doesn't involve a sexual component?
No, Knox makes that very clear, where this court held that there was a series of kidnappings. I think there were a total of 3 cases before the court.
So are you saying that it can only be 5 points, not 30 points?
No,
So what, I'm not clear what your concession
in this
was.
particular case, the only proof that we had was from the probation report that he had hit his son in the back of the leg with a board.
Right, but I guess my point is that assuming that there is no sexual component, that means that the court could not award 30 points for some other reason?
That's correct. For that case, in this...
Where do the guidelines, where does anything say that that's the case, that it's required to have a sexual component?
I mean, it does it as a blanket for all, that endangering the welfare of a child shall be considered as a factor to be considered
It's
as
30 points, right?
for 30 points. Correct.
So what are you conceding?
That in this case, I'm saying that this case, based on these facts that were before the court, I'm saying that the appellant is right.
Right
But there may be
Right
other,
about-
there may be other cases.
There may be other cases
involving
where it is
this
appropriate.
kind of crime.
Correct.
Where that point score would be appropriate. But you are conceding that in this
In this
particular
particular-
case.
that's correct.
That 25 points, well, the people would take the position that the court should not count 25 points. A court may hold otherwise.
Yes.
Your concession is.
And why is
you're
that?
right.
Yeah.
Why is it not 30 points in this case?
Based upon what the proof that was shown to the trial court in my analysis, maybe my 20 years as a defense attorney are showing in this particular case. But prosecutor...
How does our
from-
Howard analysis impact your concession?
The-
You conceded this before Howard was decided.
I don't know. I can't answer that. I'm drawing a blank on Howard right now.
Well,
I
Knox and
apologize.
Howard are about a statutory, right? It's about a statutory presumption.
Okay.
That even if sex is not involved or it doesn't have a sexual component, nevertheless, they're treated as a sexual offender for purposes of SORA.
Similar to Knox. I'm saying in this...
Well, yeah, same statute as Knox,
Same
yes.
thing.
You
Doesn't
don't
the
have that, this
reasoning-
statute
wouldn't the
doesn't fall
reasoning-
under that
Yeah,
category.
but wouldn't
does
the
it?
reasoning in Howard still apply, even though it's not a sexual component to it? It's endangering the welfare of this child.
You see endangering in a lot of cases. It can be arranged from inappropriate supervision, excessive discipline. It can also be used, quite frequently, it's used to domestic violence cases between a husband and wife or 2 parents to elevate a harassment case to a misdemeanor.
Yeah, but we know in this case that the child was hit with a 2x4 board and was bruised badly, pretty much like, not as badly as the child in Howard, but still, the child was bruised pretty badly. It's not a failure to supervise. This
I'm
was
also
an
taking,
active-
there's also 20 years difference between, I think 20 years from the time of that conviction and the time of his plea to the sex offense. And just conceding it for this case, not under these set of
Was
circumstances.
the Sora court entitled to credit the statement of the victim in this case?
Yes, Your Honor. I believe there was sufficient, it does meet the requirements of Mingo and Ballack. They do have the sworn statement. There's two statements made by the victim. They're both consistent. The sworn statement made to the arresting officer, as well as the victim impact statement in the probation report. In addition, you have corroborating statement by the victim's sister that throughout the time period between when she was a teenager, that she would have bruises, and she would tell her that her father did it, and that she was basically getting special treatment, and for lack of a better term, being bribed or paid off. That all goes together to each of those support that statement, and that, I think that does meet the qualifications, what's required by Mingo and Bailey.
Given your position on that and your concession on the first issue and those 25 points, what is your recommendation about how we should treat the case? What should we do?
I would like to see it sent back down on that issue.
To go to the SOAR court to determine what?
To go to the SORA court, well, this court has several options. You can discount that and impose a level 2 or whatever the score, the risk assessment would be without those points. I can tell you what, and I anticipate that. We have the option, as does the appellant, to petition the SOAR court for a modification after a period of years.
So you haven't done that?
It would be a moot point. The judge would look at it and say, he's a level 3, what are you doing here?
I'm still a little stuck on the concession here. The commentary, the guidelines say, the board decided to treat endangering the welfare of a child as if it were a sex crime because generally involves sexual misconduct, especially when part of a plea bargain, but that where a review of the record indicates that there was no such misconduct, a departure may be warranted. So your position is that it was an abuse of discretion for there not to be a departure in this case?
The departure should have been made. Yes, it should have been made. Because it was not this case. It was not a reduction down. We had no proof of that. The only proof that was there was what the probation officer discovered and put in his report.
What if it was outweighed or outbalanced by other factors? For example, the severity of the acts of that and the nature of the alleged sexual misconduct here. Isn't that what you would be arguing for your upward departure?
Which wasn't reached at all because
So if you're arguing there should be an upward departure and they're arguing that it should be a downward departure, wouldn't it be within the judge's discretion to say, no departure, I'm sticking with the points here?
yes, it would be within the judge's discretion for that.
Okay.
Thank you, counsel. Counsel?
Thank you. I just want to clarify, the child that was involved in the EWOC conviction is not the complainant on the underlying offense here, on the SORA offense. It's a completely different child.
It's a son, as
Right.
opposed to, yeah, I
Right.
understand that.
So it's unlike Howard to the extent.
Is that the test? Is that the standard? that
No,
has to be-
I just want to make sure that the court is clear on that, that's all,
Oh,
because
okay.
it sounded to me as if it was being considered something like Howard, but that's not true at all. I do want to refute the allegations that the sister somehow corroborated this. In fact, the sister told police she didn't know anything about, she'd never seen any kind of conduct like this, that she didn't the father didn't come in and take the complainant out of the room like the complainant said she did. She did say, I saw bruising, but there was no timeline. She didn't say it was when she was a teenager. She said, I've heard about this, but didn't give any kind of indication whether this was when the complainant was an adult or at any other time. And there's no indication in the record that the father offered the complainant special treatment or bribed her in any way at the time that she was a child. That just is not in the record at all. If there are no other questions, I rely on the brief.
Thank you, Counsel.
Thank you.
Thank you.